About a year ago, I had a problem with my sofa, which I bought on 0% finance, and the finance company tried to mislead me about the law, of all things, and this is an update on that story. But there's also a fantastic ending to this story because another company, Valencia Theatre Seating, came to my rescue. More about them a little bit later. But first, let's do a bit of a recap. So this sofa of mine cost thousands of pounds, and within a year or two, it started dipping and making all sorts of noises and clanking and mechanical sounds, and, well, take a listen for yourself. So I get in touch with the finance company because, for reasons I'll have to explain, I bought this on finance so that I get protection under Section 75 of the Consumer Credit Act. More about that in a moment. So I ring up the finance company and say, this is protected under Section 75 of the Consumer Credit Act. Now, is it better that I speak to you or the retailer of the product or what? Because you're jointly liable. She at first said, yes, we'll take a look at it. You're protected under Section 75. Let's get you fill in a form and tell us what's wrong with it and all of that sort of stuff. So I do that, and then I get a call a couple of days later. Now, albeit this was on the telephone and nothing committed to writing, she rings me up and says, unfortunately, now I do detest the word unfortunately before someone gives you bad news. Just spell it out. Maybe that's the lawyer in me. But she said, I don't know how much you know about the law, but you have 30 days to reject something if it's not good enough, and then you have 6 months to get a repair or replacement. And wait for it, unfortunately, you're outside of both of those timeframes. So obviously I responded to that to say, well, I don't think that's quite right. Actually, what the law says is X, Y, Z, and went on to have a discussion about the law. So right from the outset, in my view, she was trying to mislead me. Or if I'm being a little bit more charitable, she didn't know. But the point is that she should know. If she's talking to me and telling me what their position is on the law, on my potential claim against them for a defective product, what the law says about Section 75 and the Consumer Credit Act. So let's talk a little bit more about what happened, and then later on I will explain a bit more about the law and what you might do if you find yourself in this position. So actually, after that call, the retailer did come out. They sent an engineer out. They twiddled some bolts and they tightened things up. They told me that they could replace the foam if it continued to dip and so on, although I'd have to pay for the foam. Now, they did tighten things up and the noise did disappear for a short while, but the noise has gradually come back and the sofa's continued dipping. So overall, I don't think that that stands the test of time, and I don't think it's worth the money that I paid. But the question here is there really a claim in law? Well, the thing is, when you buy something brand new, the law says you can have higher expectations of that than something that you buy second-hand. And this goes for furniture, it goes for vehicles, and so on. So I get lots of clients come to me with new and old products and vehicles and things like that, all of which would be dealt with under the same law. So I was left once again in the position of contemplating suing the retailer and or the finance provider, or back into the marketplace to find something that was of superior quality, which is where Valencia Theatre Seating came in, because they'd obviously seen my videos and they agreed to step in and help me out. Take a look at this. This is Valencia Theatre Seating. As a working professional, much of my day is spent at a desk, whether that's drafting or in conference, and so in the evening I crave optimum comfort and design. So when I sit down in the evening to watch a film and relax, I want something with lumbar support, which this Valencia seating has, because there's a middle section here of these buttons which allows you to bring out the lumbar support whenever you need it. But also you can save that as part of the overall memory settings when you press the I button, which will just bring the chair out into exactly the position that you've saved. So you can just sit down and relax, ready to watch the film. If you want to relax a little bit more, you can just extend it that little bit more manually. And then if you want to bring yourself back to the position that you know you like, you press that button again, it brings you back there again. If as invariably I end up doing, you want to do a bit of work and you need to sit up a little bit more, you can bring the chair back in, you can bring the headrest back up to give you some head support, which is really thick and comfortable, by the way. And then you can have your laptop here, which I spend a lot of time sitting here working as well as an extension of my office. And then when I'm done, I put the laptop down. Literally, it's always to hand somewhere. Then you can press that I button again and sit back and relax. Not only that, you can have your drink here, so it's always to hand. There's also an attachment here for accessories to hold a wine glass or phone or iPad. And there's also no hunting for the remotes anymore because they're always in the box here, which by the way is really soft and luxurious inside. It's like sitting in a luxury car to watch a film. And all of the remotes are down in here. So I most certainly approve. Best sofas ever. These are the Tuscany Luxury Edition, which can be configured as a single chair or with the help of these simple yet sturdy clips, double, triple, or however many chairs you need to fit your room. Handmade from Italian Napa leather with exceptional craftsmanship and French diamond stitching, luxury is the standard on these chairs. So I hope you like my attempt to make this a little bit more cinematic and interesting, and you know that I'd never recommend a product to you that I wouldn't use myself. These are genuinely the best sofas I've ever had. We've had lots of different sofas, including the ones that I've been talking to you about and complaining about because they just weren't up to scratch, but these are genuinely so much better. There is a link in the description. There's a huge sale going on at the moment. It is an affiliate link, but don't miss out on this huge sale. It's Valencia Theatre Seating. My link is in the description below. Please do use my link, and I appreciate that. And you won't be sorry. There's lots of different designs to choose from. There's lots of different configurations and colors and price ranges and so on. And treat yourself. Why not? If you spend most of your evenings sitting back, relaxing, watching a film, the least you can do is do it in some style and do it in some comfort. So check out Valencia Seating in the description below. I hope you enjoyed this little montage in the middle. But now let's get back to a discussion on the law, on when things do go wrong, like they've gone wrong with my other sofa, which now I can happily push aside. Let's get back to it. So let's jump back in and talk about the law a bit more, and I'll also guide you through the process in case you need to sue either the manufacturer and or the finance provider in the event that you've had your product on finance. Now, as I said, Section 75 covers you if you've bought your product on finance, but here's a little bit more about the detail on how that works. If the purchase is between £100 and £30,000 and any of it has been paid on finance, then the finance company is jointly and severally liable with the trader for the purchase of that product in the event that there's a breach of contract, either the written contract or any of the implied terms by the legislation. For example, in consumer contracts, the Consumer Rights Act implies terms into the contract, meaning the contract has these terms whether the trader likes it or not, and they become a part of the contract for things such as it's got to be fit for purpose, it's got to be satisfactory quality, it's got to match samples or examples and things like that. It's got to be free from defects, which usually mainly applies to things that are new. And in the event that something deteriorates over time, then there's arguments as to whether or not it was defective at the beginning, which is where the discussion with this person from the finance company comes in, because we had a slight disagreement about how the law works. Now, initially, you get a 30-day period to reject something if it doesn't conform to the contract, either on the written contract or under the implied terms by the Consumer Rights Act. So the Consumer Rights Act itself provides you a right, a short-term right, to reject that product within 30 days if it doesn't conform to the contract and any one of those terms, specifically within that contract, are specified and set out within the Consumer Rights Act. That's the first 30 days. And that's if you bought something in person. There's a slightly different avenue you can go down if you bought it online. That is a 14-day cooling off period within which you don't need a reason to return it. You can return it 14 days beginning the day after you receive it. But let's just talk about when you've gone in to physically order something in a shop. And this is a straightforward purchase. You still get that 30 days within which to reject that product. That's obviously from when you receive it. However, after the first 30 days, and this is where the disagreement came in, after the first 30 days, you then have within the first 6 months the right to a repair or replacement. But here's the key distinction between the first 6 months and after the first 6 months. Within the first 6 months, if a defect arises and you discover this defect within that first 6 months, it is deemed to be there at the point of purchase or the point of delivery, because it's within the first 6 months. As the saying goes, if it's going to go wrong, it will usually go wrong within the first 6 months. So if something just doesn't work properly within the first 6 months, it is taken to be there at the outset. And it's the trader that needs to prove otherwise. So for example, if you've incorrectly used something and they can demonstrate that, or if it's smashed and obviously it wasn't smashed when you bought it and they can prove that that's the case, then the onus is on the trader to prove that that defect was not there when you bought it and it's your fault. After the first 6 months, that burden shifts to you. You need to prove on the balance of probabilities, and we'll come back to this in a moment, on the balance of probabilities that it was there when you bought it. But that's then your burden. You need to show that this was defective when you bought it. So what do you do in that event? Either you're within the first 6 months, because I get this all the time as a lawyer. I get clients come to me all the time to say, this has gone wrong, but they just won't accept liability. And most companies, invariably, most companies just don't accept liability. They say, no, your problem, this is after the first 30 days, or they make up some excuse. So many people will say it's outside of the first 30 days, so nothing we'll do about it. But the Consumer Rights Act, assuming you're acting as a consumer, the Consumer Rights Act provides you with a right to a repair or replacement within the first 6 months. As I said, if a defect arises in that time. So let's say you've gone through all that discussion and they just don't try to accommodate you. They just won't have it. Then you've got no choice but to file online. So this is the Money Claim Online system. This is logged in as me of Shen Smith Law, my firm. Now, this might look slightly different to yours because I'm authorized and the firm is authorized to conduct litigation. So we file these claims through this portal on behalf of others and, if necessary, on behalf of our own firm. But for that reason, it might look slightly different to you. So what you would do here is it's a very simple, straightforward process. As I say, it will be broadly the same if it's your account logged in. You'll sign up and log in and so on. You get a government gateway ID. You begin a new claim and you go through, and this is asking me to sign in again because I've been logged out from being in there for a while. So you begin a new claim and you go through. And as I say, this might look very slightly different to yours, but it's broadly the same. You've got the fees allocated here for claims that don't go above £300. So anything up to £300 is only £35 to file. And then more than 300, but under 500, up to 1,000, up to 1,500, and so on. And over £10,000, then it turns into a percentage rather than a figure. And then obviously it is not a small claim anymore. More than £10,000 is no longer a small claim. What that means essentially is that you're at risk to costs after that point, because the small claims track, which if we zip over to the civil procedure rules here and we look at the small claims track, which is here, the scope of this part is that a monetary claim is any claim which has a financial value not more than £10,000. And so there's also other distinctions such as personal injuries or any tenant-landlord claims and things like that. But otherwise, you'll have a look at the fees that are here. It gives you an outline of what the claim is going to cost you to file, as in you file the claim and then the court will issue a number. So here's the process of what happens. You file the claim, as in you're telling the court about the claim. The court will then issue the claim, then it has a claim number. Then you or the court, which we'll come back to in a moment, you or the court then needs to serve the claim form. That means you give it and make the other side aware that the claim is progressing. So you'll click continue on this online system. Then you'll start, you can give it a reference so that you internally, yourself, you know what this claim is about. Now, this is where mine and yours might look very slightly different. Mine, I'm obviously going to specify the individual or an organization and put the details in, and you'll go through and you'll put your details, the defendant's details, and that will obviously be a company if you're buying from a company. Importantly, with the Money Claim Online system, you can have up to 2 defendants. So that's convenient because there might be a trader and the finance company if your product was on finance. If not, then you just obviously name the trader. And then there'll be an option to include all the details within this form or to send further details afterwards. So if it's very simple, you might just want to stick to this system, or you might want to set them out separately. If it's fairly complex and there's lots of issues involved, then you might want to come to somebody to have the particulars of claim drafted properly. That's something that barristers will very often do, to draft properly these particulars of claim. And then typically when you do this online, the court will serve the claim form, and then everything is in motion. But obviously, as a caveat to all of that, you should really try to resolve matters with the other side first before filing a claim. In other words, you should follow the what we call the practice direction on pre-action protocol, which essentially means giving the other side, setting out by letter, a letter before action or a letter of claim, sufficient detail so that they can meet the claim when they receive it. So they can have the opportunity to respond to it even before you file it with the court, because court should always be a last resort. But assuming you've done all that and there's no response, or they've denied it, or it's quite clear that they're just not going to play ball with you, then you might have no option but to file a claim. And then ultimately it will go to court, and you'll have to follow all of the directions the court makes and the rules, such as providing evidence and so on. You might need to seek advice at that stage, although just bear in mind, if your claim is not more than £10,000, then it's going to be allocated most likely to the small claims track, meaning you won't ordinarily get your costs back. Although there is a small provision within the civil procedure rules whereby if a party, what we describe as behaves badly, that usually means they don't comply with the rules and the directions of the court, then there is a fairly discreet reference within the rules, which is the Civil Procedure Rules Part 2714G, which is where the court can order such further costs. This is in addition to the filing fee. Further costs, assuming you're successful, as the court may assess by the summary procedure, that just means without another hearing, and order the other party to pay that has behaved unreasonably. As I say, that's usually referring to when they've not complied with the court order, they've not provided evidence, or all of those kind of things. So that's what ultimately you might end up doing. But I've got various other videos on that as well. I hope also that it's clear how the Consumer Credit Act does protect you. So once again, if your purchase was between, not the amount that's on credit, but the purchase was between £100 and £30,000, and any of it was paid using credit that is directly linked to the purchase. So it doesn't work if you go off and take a personal loan, because then you've got the cash and then you pay for something with cash, because there's no link between the loan and the product. There has to be a link between the two. And so if you take out, say, retail finance or directly financed goods, then it will be protected. And you'll have all the documents that will tell you. So if in doubt, read those documents to check that you are protected under the Consumer Credit Act. And that's even before you sign it. You'll get what they call the pre-contractual information under the Consumer Credit Act. So it will set out exactly what your rights are going to be before you enter that contract. I hope that's useful. I hope my little story of woes with my sofa has entertained you. But please do check out Valencia Theatre Seating. They are the exquisite sofas that I've ever had the fortune to sit upon. So thank you for your time and your attention, and I'll see you next time.